I guess we're live now since I've been told. Then, thank you again for all of you guys for joining me today. My friend Leonard Ty, who also works at Galactic Entertainment as a Senior VP of Operations, was supposed to join us today, but he's not going to be able to make it. So, again, thank you for your time today. If each of you could present yourselves, do a quick intro, what you do and who you represent, I'll be very thankful for that. So, shall we start with you, David?
Yes, hello. My name is David McCarvilll. I'm a director at Fennemore Craig. We're a US-based law firm, and I work in our cryptocurrency and blockchain practice group. I've also been teaching at ASU Law School, a course on blockchain and cryptocurrency law and policy since 2018. I'm happy to be part of this conversation, so thank you for your time and attention today.
Thank you. Then, Matthieu, if you would, please.
Yeah, thank you. Hello, everyone. I'm Matthieu Quiniou. I'm a lawyer in Paris at the law firm Legalbrain, mainly working on blockchain issues and AI ethical aspects. And I'm also a researcher at the University Paris 8, mainly on those topics too, but with a background in technology and information communication, so not in the field of law. And I'm also working with the Atto company, which is a tool for Web3 that integrates embed licensing for NFTs.
Right. And of course, Gabriel.
Hi, everyone. So my name is Gabriel Jaccard. I'm finishing currently a PhD on smart legal contract. I've been saying that for maybe 2 years. I've been doing it for like 5 years. And I'm the CEO of Arbitri. Basically, it's a one-stop shop based in Geneva. So I focus on the legal area myself, but we have other services, and the whole idea is to combine services together to produce like the maximum, amount of happiness towards our client, and make sure that we kind of bridge, the domains all together in order to have a very successful project.
Awesome. A lot of great minded people here in the space, especially on the legal side, which is what we're here for, and we need your advice and help. My current job is working at Distruption X as a partnerships director. Distruption X primarily is a Web3 gaming platform focused on esports and guilds. And also my own current jobs, I am a game scout and a Web3 gaming advisor. So specifically focusing on the gaming side, which is why we're here today as part of the BGA Alliance, I want to bring up our good friend Gary Gensler from the SEC, as a couple of days ago, during a conversation, during a meeting, he did say that, from his point of view, that 99% of tokens are securities. And as we're in a space full of games and full of different tokens, what would be your kind of point of view on that comment from him, on the specific and the legal definitions of a token?
I'll take this one since I'm the resident U.S. attorney and Mr.
You can go
Gensler
knock
has
on
been
his
causing
door,
havoc.
hello for us.
Yeah, if that's okay. So what's interesting is in the United States, you're seeing sort of a battle over jurisdiction of cryptocurrency, and the CFTC, Commodities Futures Trading Commission, I think is probably going to take a fair amount of the jurisdiction away from the SEC. At least that seems to be what Congress would like to see happen with the pending Loomis-Gillibrand bill, which will probably pass next year. The CFTC has been critical of Gary Gensler and the SEC because they've been primarily regulating via enforcement and litigation, and they have not been issuing any proposed rules to solicit public comments and to make rules that way, which is really how most of the laws in the United States are made, is through federal agencies like the SEC publishing a notice and then accepting comments and eventually adopting a rule. The SEC has been nothing but chaos since the 2018 initial coin offering boom. During that time frame, a lot of clients came to me and said, hey, we need an opinion that our ICO here is not going to be offering securities. And I said, I really can't do that because it looks like a security under the current test, which is from a Howey case back in the 20s. And so, there's a lot of confusion, but ultimately, I think the right answer is that most of these tokens are probably not securities. The Howey test resulted from a piece of litigation around an orange orchard in Florida that was selling contracts to people who were making money on the potential management of the orange orchard. It wasn't for the sale of the oranges. And I think in the digital asset space, one thing we can look at is that these digital assets are really more like the oranges rather than a contract for the profit of the orange orchard. So I will say that I think Gary Gensler's time in terms of causing chaos is hopefully coming to an end next year with the passing of the Loomis-Gillibrand bill, and we'll get a little more clarity in the space. Thank you.
Would any of you two want to add anything else to that? Gabriel, Matthieu?
Yeah, definitely. It's all about qualifying tokens. It's all about the definition. There is like a lot of fear going on when someone pronounces a sentence like that. I believe it's counterproductive. I would definitely agree with David when he says that most of the tokens do not actually pose much problem. I mean, the whole game nowadays kind of trying to make sure that the token is not a security, so that you're able to list your token, etc. So I believe that the people who are also tends to organize themselves, from a legal standpoint, they really try to actually make everything possible to actually void this definition. So just saying that is very anxiogène, as we would say in French. So it creates fear amongst nothing. And this is also maybe a great view of also what the authorities in our modern times look like, because we kind of need to have also some very comprehensive authorities to make sure also that what we do on the blockchain space has also some legal validity and can be normalized. And those kind of political statements in the end are not really productive, and it's something that we can regret, definitely. Yeah, but it's not everywhere like that, hopefully.
Yes, as in every country has its own different laws when it comes to crypto, especially with a recent crypto law in America signed up by Joe Biden, I believe. And then also here in the UK, the attendant or the amendment of crypto law. I also believe we could move to Matthieu, especially in Paris, where even with Binance kind of setting up their own HQ, I believe in Paris, and also kind of pushing more for the crypto side. What does the definition look like when it comes to each country?
Well, in France, it's quite different. I think it's less rigid than in US, and even less rigid than in China, for example, where everything is banned, not only the security tokens, but also the utility token. We've seen what has been done for ICO, for example. And currently with NFT, it's not clear how to issue this kind of NFT. We have to call it another way, and you have to go through specific companies in China to do it. So it's quite hard. In the US, there is the Avocats that is really broad acceptance of what's a security. In France, we have a definition of the utility tokens that is specific, created by a law that is called Loi Pacte, which is totally French law, created during the ICO period in 2019, I think. With a definition of it. It's mainly related to an ecosystem with a utility. It's mainly that, and working on what's called in France a DEEP, which is clearly a blockchain, a public blockchain. So if you have it and it's not with, for example, a specific return, and it cannot be qualified as a share, then it can be totally legal to do it. However, when you want to issue more than 150 utility token, well, you're supposed to go through an IMF labeling. Otherwise, you are not really allowed to, well, communicate broadly on it. So in terms of communication is quite limited. So it's quite hard when you know what's happening on Twitter, on Discord, on any social network. So, well, it's mainly related to that. And we also have in Europe a project of regulation called MyK, which is, well, addressing the issue for the whole European Union to address the question. It's quite close to the definition we already have in France. For example, you talk about Binance and the label they get. It's what we call PSAN. In French, it's Prestataire de Services sur Actifs Numériques. It's mainly you've got, you are, well, a platform that is, well, dealing with secondary market or primary markets with digital assets. And to do that, you're supposed to have an AML, what we call LCBFT in French, but an AML system, anti-money laundering with KYC, etc. And so you have to proceed well, in front of an authority, which is called the AMF, which is the equivalent of the SEC. So we've got that, and it's also implemented on the MiCA regulation. So, well, it will mainly be the same thing, I think, in Europe in the future.
Yes. Especially when people are founding new companies in the Web3 space, they tend to found them in, say, the Bahamas, or in the British Isles, or within Dubai. So is there a pro and a con if I would say set up a company in Europe instead, America, versus setting up in a country like Dubai? Now, imagine the most general thing is to taxes, right? But Gabriel, please jump in there.
Yeah, I would love to actually answer this question, because we get this case all the time. You just explain a complicated situation to your client that looks at you, dead in the eyes, and say, I'm gonna go to Dubai. And the truth is that in the end, it's really counterproductive. Especially, I've seen many people doing ICO in some exotic jurisdiction. Let's not mention any name. But in the end, they kind of want to operate the whole game or the whole project from somewhere else. So they kind of need to move the money. So they kind of had some kind of a tax break in the beginning, but still they need to have there is some tax implication when you move the money from point A in this exotic jurisdiction in point B. And the problem. And the problem that I see is that actually people don't really tend to see the value in the legal stuff, and I fully understand. It's complicated to see. In cross domains approach. Where's the value? What a legal regulatory strong framework like in the EU or like in Switzerland, maybe like in the US if the CFTC takes over. It's really that you can see long term, and that you can build your project upon, and I really don't think that going in a very exotic jurisdiction where they just want to attract you based on the tax law and stuff like that is a very viable way to actually maintain the project in the long run. Because what we see more and more, and what I see in my practice, is truly people that were successful in the beginning and that tried to come back at sometimes very heavy cost back in where this operational area is, usually in Europe. So yeah, that would be kind of my take on it. So I won't say it's a bad thing, and I won't. It's not a social discussion about whether the tax is fair or something like that. It's really about developing a project where you are at ease, where you know the law, and where you know also that you will be able to build on the long road to come. And yeah, that would be really my take in the end. Yeah, if it's Dubai, it's Dubai. But I mean, most of the time, I don't think it is.
Yeah, great. I think this question is more specifically focused on you, David, regarding what the purview between casino and crypto games are looking like. When Valve were kind of looking at doing crypto and blockchain gaming, and they're operating out in Washington, they would fall under the kind of gambling license for their games, right? And Valve kind of took a step back and said, look, we're not going to do this, but we're going to have a look at it. So in country by country basis, I think right now for America, what does the definition kind of abide by?
Yeah, very good question. So the definition for gambling changes depending on which state you're looking at. So America has a very complicated system of federalism where we have federal law that is supposed to preoccupy any rule from a federal agency should occupy the field, and the states cannot make any law counter to that. At least that's the rule. Now we see that not exactly playing out in terms of marijuana legislation or immigration legislation. So, but as a lawyer, that's the way it's supposed to work. If the federal government adopts a law, then the states need to abide by it. In practice, we have this sort of new federalism which belies that. But when it comes to gambling, the federal law is basically, look, it's up to the states. And so you have this overlapping jurisdiction between states, especially for online gambling, where it becomes very challenging for an online platform to navigate getting licenses from all different states. So, but the gambling laws vary by state. And the general test for gambling is 3 factors. Number 1, staking or risking something of value. Number 2, upon the outcome of a contest of chance or a future contingent event not under the person's control or influence. And then number 3 is upon an agreement or understanding that the person or someone else will receive something of value in the event of a certain outcome. So that is the rough definition of gambling. But again, each state takes a different view. A state like Utah really frowns on gambling. They do not allow it. Heavily Mormon population there. I think Hawaii is also another state that is not allowing online gambling. But it's becoming more and more of an issue here, especially with online sports betting. That was just recently passed in a number of states, and it is a huge business. So we're seeing online gambling really taking off. And you know, some people think it is bad because it's basically just a tax on people who are bad at math. But you know, it's coming, and it is another way for perhaps online gaming companies to become compliant and move themselves out of the securities regulation clearly by just embracing the gambling regulations and going through licensing for those products.
That's because we're Web3 gaming. We're kind of living in a gray area, right? As games need, if they need to be published, they need an age rating. But Web3 games don't require an age rating to be played or to be published. Outside of publishing a game on Google or Apple, which is kind of a lot of our BGA members have difficulty doing so because there's no standardization for doing so. So I would say in that aspect, for other countries like Switzerland, for you, Gabriel, or for France, is there kind of different laws for gambling? Because I know Switzerland is very strict on that as well.
Yeah. So actually, the definition of gambling is, let's say, pretty much vague everywhere. So in Switzerland too, we have this also this specific list. So basically, we have a blacklist of projects that do not really respect the Swiss gambling law, and so currently the Swiss law has been revised. I believe it was in 2021. But the concept and the thing that it states are still very vague. We speak about, you know, gambling law, things of value and stuff like that, things that can be interpreted rather largely by the authorities. And what people don't necessarily know very well is that actually our authorities, the gaming authorities, have been quite strict, and they have been trying to also get some momentum, get some competence in the blockchain area. And for instance, people don't really know that, but for example, CryptoKitties, which seems like a harmless type of activity, is actually forbidden in Switzerland. And you have a blacklist of games that the authority deems to be non-compliant from a gaming law perspective. And they address this blacklist, and CryptoKitties is on it, amongst others. My vision about that would be to say that, okay, the definition is pretty much everywhere the same. It's pretty much vague. So there is a huge burden on the shoulder of the authorities, whether they want to actually enforce, make some enforcement or not. The end result is that we don't see many adaptation being made, and we see the regulatory system being kind of slow. And I mean, some of us and some of maybe people in the audience have maybe dealt with people that are active in the financial law, so they know very well financial authorities, because the first steps were made in the blockchain era by the financial authorities. But now we will see more and more some different authorities that gets to be kind of in the game, and that will be kind of maybe uncomprehensive and trying to apply their own law, and sometimes applying it at the detriment of the people who just wanted to create a game or some stuff like that. So that would be my take. It would be quite similar actually to what David says. Very vague definition of what is gambling, and a law that is actually quite recent, but it's quite old in its way of thinking. Yeah.
I can see you talking along, Matthieu. I guess you have some opinions of yourself and what you've been seeing as well.
Yeah, in France, it's quite different, I think. It's really rigid in terms of gambling. It's mainly a state monopoly by Française des Jeux. And for horse racing, it's PMU, which is a kind of association which is really, really old, with a monopoly too, but only on horse racing. Otherwise, we've got casinos that are private. It's really hard to create one. You cannot do it, for example, in Paris. you have to do in some specific area close to the sea, and you also have to have, for example, a museum in the same place. Well, it's really strange way to decide that, but it's a public territory regulation. And for online gambling, it's quite recent in French. It's really rigid. It's only possible to do poker and sport bets. It's the only things that are allowed, even for casino that have a physical place. It's not possible for them to do it online. So it's really difficult for, well, French company to propose something. And for what we see generally for video games, it's mainly about what we call jeu concours. And we've got like, a burden of evidence in order to check if it's really gambling and hazard or if it's okay. You've got to create like terms and conditions that are specific to explain the consumer is right and to be transparent. One of the evidence is that it has to be free to access. Well, you can pay, but you can also access it for free. You have to see a bailiff, for example, even if it's not mandatory now. It was like several years ago. Now it's facultative, but it's a good thing if you have done that for the burden of proof, and you've got several criteria like that in order to prove it's not illegal. So, well, it's really rigid in France in terms of gambling, especially online.
Yeah, it's a very interesting space, even with South Korea, that any game, even made in South Korea, that's on a blockchain can't be published in the country itself because it falls under the line that it's real assets being won. So even in countries such as South Korea, which seems a bit more progressive in terms of the gaming side, is still quite behind when it comes to allowing games to be published in that country and being played. And even with different monetizations such as gacha, loot boxes, loot boxes themselves are banned in Belgium, banned in the Netherlands. No games that have those mechanics can be played there. But with other mechanics, are we seeing a very similar thing with Web3 gaming with crypto? Are countries kind of taking steps to be like, we're not really going to allow games to be played in this country or be published in this country? Or what, anything you've been seeing from that side? Anyone can jump
this
in.
is David. I'll take that one. So, I think this might be the one area where the United States is a little less problematic. There are still a lot of uncertainties around securities and so forth, but with regard to NFTs in game and how those are used, I think you can see some examples with the Ghost Recon NFTs where it can work as long as it's confined to the game. What's going to be interesting is when you start to see an open marketplace for trading these NFTs across blockchains and across different games and being able to use them, different skins, for instance, in different games. And once those begin to be traded, bought and sold and transferred between games, that's a whole new level. And I think that's where there is a great deal of uncertainty. But as far as, creating NFT loot boxes and having those within the game, I think that is manageable. That's a little bit clearer in terms of how to navigate that from a regulatory compliance perspective. It's when you start breaking out of the walled garden of the game itself and start to transact on more of an open market where you're going to have issues with money transmitter licenses, with FinCEN, potentially with the SEC if it's a security, if they deem it to be a security. So all kinds of potential wild cards once you get outside of the game that it's been created for. But yeah, I think that's one of the more exciting use cases is, NFTs in game and the bundle of rights that comes with the NFTs, intellectual property rights that are being conveyed in a fascinating space. So leave it to blockchain and crypto to make even securities law and IP law interesting. So that's my take.
As anyone else wants to jump in there, like any more information? No. I was going to ask another question, even for myself as a game designer. When starting a new company in the Web3 space, is there any kind of steps we have to take legally that when we're setting up a new company ourselves? And I'm sure you've been getting this question beforehand from other individuals that are stepping in from the Web2 space into Web3, who are like, I know how to make a Web2 company, but what about the legality of Web3? Should I make sure it's done and double checked? David, Gabriel, Matthieu, anyone jump in for that?
So yeah, Maybe I can. So in my view, there is not that much difference. Creating a company is always creating a company, whether you make it in Web 2 or in Web 3. I believe it's more about creating some kind of a nexus of a company, because it's all about creating some kind of an ecosystem that makes sense overall. So it's more actually. So for instance, I've created several. DAO association. It's a model that we have in Switzerland. We're able to create DAO association. So creating a DAO association, creating like a company that will serve like really as the motor of the whole exploitation of the game and makes the money, and kind of make sure that this nexus of entities kind of work well together. I believe that would be the case. Usually, when you do an ICO, when you want to raise some fund, it makes sense to have a corporate entity, because you don't want the money to be raised via usually an association, stuff like that, because this money will need to be invested, and you need to have like some kind of a business model in the end of the day. Even if everyone has good intention, everybody needs a business model by the end of the day. And I think it's what it would change. Now being said, that a company stays a company even if it's Web3, I believe there are some distinctive change in Web3 that may apply. For example, we have many people that come to us and say, okay, now I'm kind of not really a believer anymore in the banking system and stuff like that. I want to kind of get out of banking, and that's also some things that is kind of possible to some extent. And for example, holding the assets of the company, be it a mix between fiat and crypto, is kind of something that you should adapt. But it's much more on a second phase, when you're at the operational, when you have the operational view of the company, when you need to handle accounting, stuff like that. It could change something. So yeah, I would say that as of now, it's still a company, but there are some new challenges, especially linked to the fact that you handle cryptocurrency in the end, and you need to actually make sure that the interest of more than just shareholders are actually met with So that's what I would say.
Yeah, Haroon, just a couple of quick comments, and I agree with everything Gabriel's just said. I mean, look, it's still a business. You want to make sure you follow the same business principles. But what's different about Web3 is that you have highly regulated environment now. It's probably over-regulated, in my opinion, especially here in the U.S., where you have overlapping state and federal jurisdiction, in addition to different agencies trying to regulate. But what I think are existential threats for companies in this space are money laundering threats, where you don't have sufficient KYC AML in place, as well as AI and bots basically moving in. So when you're in a gaming environment, you want to know if you're competing against an AI bot or against a North Korean ring of computer hackers who are going to basically steal everything, like they did with the Ronin hack and Axie Infinity. So I think, look, there's a certain cypherpunk mentality, which I agree with, which is that privacy is very, very important. But when it comes to being full anonymous, I think there are some problems when you start dealing with money, trying to maintain anonymity, which is you're going to invite the Democratic Republic of North Korea to come in and use their people to program and steal, and you're going to have some bad actors come in. You're also going to have some AI bots coming in that are going to be taking advantage of people. So if you want a fair gaming environment, I think you have to be confident that you're dealing with other people, and that there is some level of regulatory enforcement in place, at least on the entry point, to make sure that you're dealing with the real human being, and that they are of age, that they're not just doing this to launder money. And the reality is that crypto is far, far cleaner than traditional finance. I mean, if you look at the statistics, Chainalysis report said all of cryptocurrency was 0.15% money laundering or bad actors using crypto for illicit finance. And you compare that to the accepted numbers of 2 to 8% from the UN for traditional finance, crypto is far, far cleaner. It's just that we have this issue of implementing KYC AML checks on the front end, because it is a little bit divergent from the cypherpunk sort of ethos that is in this space. But I would say there's a difference between decentralized technology and decentralized governance. And at the end of the day, governance of the games is probably going to be more centralized than decentralized. And so you need to have a good company. You need to have KYC, AML checks in place, because your company could be out of business overnight if it runs afoul of one of these laws. And so I think the Tornado Cash situation also provides an example of how you want to protect your developers, you want to protect your smart contracts. I think that, ideally, you probably want to wrap those in some sort of an entity. You want to pick a jurisdiction where they respect freedom of speech and respect unlawful search and seizures. And by wrapping those entities and those developers in an entity that has access to courts that can enforce those types of laws, I think you're doing everybody a big favor. So those are just my comments. Thank you.
Thank you. Appreciate that. Speaking of privacy specifically, we actually had a question from one of our BGA members, Sirius, Playgrid. He wanted to know regarding when it comes to sign-ins with Web2 with emails and passwords and normal kind of login details versus the use of Web3 version with Ethereum and having a token in your wallet. Is there a difference in the terms of privacy policy in GDPR when it comes to that use of certification?
Yeah, so it's a big issue because the GDPR was not conceived by taking into account the blockchain. For example, normally anonymity is out of the field of the GDPR. So if it's really anonymized, then there is no issue related to that. So there is no privacy question. However, it's not really the case. It's more pseudonymized. And when you add data, personal data into a blockchain, or when someone is using a public key in order to connect to some service, then it's considered potentially as a personal data. And one of the question we've got, for example, for NFT is for counterfeiting, and also when you have your image that is related to an NFT, for example. How can you suppress the content? Because normally you've got the possibility in GDPR as a citizen to ask for the destruction of personal data. It's difficult to translate. C'est le droit à l'image, le droit à la suppression de la donnée, droit à l'oubli, right to be forgotten. So it's kind of specific. It's from the human rights. It's a GDPR version of human rights. So it's quite hard to suppress data on blockchain. Normally it's impossible. So there is like a fundamental impossibility to fit with GDPR for blockchain. However, we've seen that new technology related to blockchain that are not only blockchain, but using cryptology are really interesting. For example, zero knowledge proof is really interesting in terms of real anonymization, and also you can authentify yourself and show that you've got certain rights related to your kind of passport or to your public key, and to process something without revealing the personal data. So it's really encouraging system, but I think it's still maybe not mature enough. It's still at the beginning. It's really experimental. So we will see in the future if ZKP is really important, and maybe we will see a GDPR 2 taking into account this kind of technology, because now it's hard to promote that because authority, don't look at it really, are not really in favor of the systems that are too experimental. So we'll see in the next few years or months.
I'm sure the EU is looking into that right now. As again with crypto, right? Every government's kind of looking into it, trying to see how they can kind of, again, centralize it, right? And also, as we said before, regarding dirty money, it makes for good headlines for a lot of individuals when they talk about the crypto hacks and all the kind of money laundering going on, especially with NFTs. Looking again for kind of any regulation within our own kind of area that we're working in, Web3 space, for blockchain companies, like especially new ones, right? With Aptos, Nervos, Oasis that's coming onto the scene, and with existing ones with Polygon, Immutable, and the like, Solana. Are there anything that the steps that they could take in terms of helping to kind of regulate the space within itself and perhaps create a framework for everyone to use?
I'll just back up what Matthieu was saying about zero knowledge proofs. I mean, I think that technology is here. Zcash has been using it for a while and it's becoming perfected. I think to see that application take off when it comes to identity management and bringing people on board to your platform, I think that should be a focus, because I think that's going to take care of a lot of the issues that people have around going through an invasive KYC AML process. None of us like to do that, but if we could just do it once and then, look, my phone has 6 different ways to authenticate that I'm here, right? It's got a GPS tracking me. It has, biometrics. It has a PIN number, it has a MAC ID, it has an IP address. I mean, there's no way that my phone doesn't know every detail about me. And I'm okay with that as long as I accept that it's encrypted and it's not available to the entire world. I think if we could just take that information and use zero knowledge proofs to provide identity management, we can combat a lot of the issues around KYC AML. We can combat a lot of the issues around AI and bots. It's the idea of knowing that your kids are safe in an environment where there's not, somebody who's a predator in there. There's a lot of different things that this technology offers in terms of benefits to regulatory compliance and law enforcement, frankly, that I think have been overlooked because of the overwhelming narrative that crypto is just for money launderers and people who like to deal drugs. And I think that's completely wrong, factually wrong. As an attorney, we try to look at evidence. I think the evidence is clear that that's not the case, that in fact, crypto is far, far cleaner. And it's actually an aid to law enforcement. If they're trying to track people, I think they're hoping that they're using blockchain rather than cash, because if they're running a pool hall, it's going to be hard to arrest them. But if they're running things through a mixer, they're going to be found. So I think that's a narrative that just doesn't get out there enough.
Interesting. How about yourself, Gabriel? Is there anything that's any kind of technology out there already, or kind of uses that we can have to provide a framework for?
So I would like just to react a little bit to what Matthieu said about the fact that the regulation is not really made for the crypto companies out there. I believe that there is like a fundamental point here that was made by Matthieu. It's truly that you have regulators, you have people that needs to actually solve a situation, and they know only one model it's a centralized model. It's having someone liable for respecting GDPR, stuff like that. And I believe it's something. If I could kind of advise the big company you mentioned, is truly in the end you need to kind of enter into the lobbying circle. You kind of need to make sure that your voice is heard. And that's, I believe, the big issue, and that's why also law and everything takes a lot of time. We saw a lot of heat in the European Parliament when there were McCarvilll, etc. And there have been some victory, there have been some defeat. But I believe that as they are like leader in the industry, you really need to move forward in this direction. Now there are some solutions. We're trying to have like solving technologies. We have this magnificent example of the zero knowledge proof, kind of trying to solve this issue that we have with regard to data protection and GDPR. In the end, it's one way to look at it. There are also some discussion from a legal standpoint whether full anonymity is met if it's anonymized for 99.9% of the individual. There are some doctrinal opinion that says that actually you need 100% certainty of full anonymity. Some others says it's not the case. So it's a social dialogue, and that's why I believe that besides the technical solution that are kind of based on the practice, I really believe that the industry should step into the arena and really make sure that their voice is heard, because it's those business models based on decentralization are brand new. And we kind of need to have some kind of adapted system, lighter system, and system really made upon the idea of a decentralized entity. At the end of the day, you still have companies, you still have, but you kind of you have a right as an entrepreneur also to have this kind of regulation being not tailor-made, but at least, enabling you to actually exist. Otherwise, you will just run into any country that is enabling your system. The problem I have with that is that we see that many of the use case of crypto and blockchain, actually they're bringing something very new and that is very functional to today's society. And if we let this go away, by the end of the day, I really believe that we will be the big loser, but maybe we won't see that today, but we'll see that in 10, 20, 30 years, when, you know, we have amazing companies that created a system that where you can pay in 1 second all over the world in 20 seconds, and we still use, you know, SEPA and banking system taking days and you know, being a total shadow actually system. So yeah, that would be my take, but I don't have much more comment than what was said before. I believe there's like huge challenges, and on the regulatory side especially, and it's really something that is dealt, actually, it's very political in the end, you know. So yeah,
it's a very interesting space, especially for you three individuals, right? You're right in the middle of it, where everyone's asking you questions like today and seeking your advice. I think primarily another question I wanted to ask was regarding when new gaming projects come along and they essentially sell and drop NFTs for their user base, and those user base acquire the NFTs and the project comes along, what legality or what kind of, because we own the assets, right? That's kind of the conversation we're having in the space. What kind of legal ramifications does a individual have that owns an NFT if a project itself just dies, right? We've seen a lot of times projects that themselves are rugged, today people just leave with the money, and they get, you know, legally wise, we can't go after them because still in the Web3 area, do users that buy NFTs for projects, do they have any kind of legal protection when that comes to that situation, or are they just kind of left in the water by themselves?
That's a great question. I'll just jump in here. So I'm not an IP lawyer, but I deal with a lot of IP lawyers at our firm, and this type of issue comes up quite often. And I think it goes both ways. A lot of times the NFT purchaser does not know what rights they have because they weren't told when they acquired it. So, you know, for those listeners who are in this development stage, think about when you are having your purchasers sign off on terms and conditions. What are the terms and conditions you're going to be giving in terms of the bundle of rights that are coming with this NFT? So there's really 4 different areas that you want to focus on. First, you want to clearly state what the rights are granted to the NFT acquirer. What are they getting in terms of rights? Also, what restrictions are in place in terms of how the NFT is going to be used, and then penalties for violations of those use restrictions. What are you going to do if a user acquires your NFT and then uses it for some purpose that is not appropriate and is clearly against the restrictions you put on it? How are you going to punish them? Can you revoke it? You know, what can you do? And then lastly, you know, what are the liability protections against claims that are made against the developer for unauthorized use of the NFT by the NFT acquirer? And we've seen, you know, for instance, with the Bored Ape Yacht Clubs, a lot of litigation going back to some of the developers there with regard to subsequent rug pulls and hacks that have happened after the initial acquisition. And so, you know, learning from those cases and changing your terms and conditions to adapt to new legal threats, I think, is super important. So having that knowledge up front is good, not just for the acquirers of the NFT, but also for the companies that are issuing them.
Fantastic. That's why I want to know, honestly. Again, because especially a lot of new projects out there are starting, and they need to also kind of talk about their IP and also the use cases, right? As we're in the space that, again, a lot of Bored Ape stuff. There's a lot of like restaurants now opening up with using the IP. A lot, even at Times Square during NFT NYC, just a lot of those Bored Apes being posted. So from other country perspectives, is there a very similar? Is that across the board in terms of IP regulation use cases, or does it differ between different countries?
Well, it's quite close because we've got the Berne Convention, so it's quite harmonized, but we've got different systems from droit d'auteur and copyrights quite different, because in France, for example, we've got moral rights, which, well, you are not allowed to, for example, adapt content specifically without having the rights given by the author. You've got several things related to that, and you cannot normally monetize these rights. So it's quite hard to do, well, convention that are dealing with this aspect of moral rights. However, we have IP integrated into many NFT. I'm doing that myself. including a license into NFT. And we've got, well, before NFT, we already had the droit de suite, what's called generally royalties by the US lawyers, and well, mainly by the US platform on NFT. It's called in France droit de suite, and it exists since the 19th century. And we have here we have a version that is more conventional than legal. For example, you pay, well, it's not royalty. Royalty generally, it's when you've got a license. If you want to keep the license, you will have to pay for it because you won a lot of money, or because it's 1 year, then you have to pay, for example, $1,000, and it's royalties. In droit de suite, you are buying something, you are making more value with it, and when you are selling it again, a portion of it is given to the author or given to the issuer. So it's quite different, and it's more droit de suite. And the question is, in France, is it a droit de suite legal, a legal droit de suite, or conventional and a new one that has to be regulated and to be understood by the law? Because it's quite new in a way. Even if we already had this system before, which was legalized and which is done by author societies that takes the money, that collect it and giving back to the authors some part of the money with some kind of strange systems to give a portion and to keep some to promote the artist and the culture. And so we've got this system in France, and it's quite, well, I think it doesn't exist in China, it doesn't exist in the US, for example. So we are quite familiar with the system, and it's really interesting to see this author association dealing with that and promoting this, let's say, droit de suite royalty system for the artist. So yeah, and what we see in France is that some of the licenses that are promoted by, for example, Bored Apes, are not really totally legal in a way. They are not exhaustive enough to be clearly considered as a real license. And I think it's the same thing in the US, because I've read that some lawyer in the US considered that the Bored Ape license was not specific enough in order to transfer IP. So there is a lot of, well, it's not clear what we can do with that. If you do like a McDonald's with Bored Apes, well, maybe you've got the rights because you buy these specific Bored Apes, but it's if you don't have a specific contract with the editor, the publisher, or Bored Ape for this specific use, you're not sure, you are in a gray zone, I would say. So I would say without having a real clear license, real specific, you really don't know what you're buying, and it's a real issue now to address that.
It's fascinating because I remember, sorry, but Steph Green, the actor, had a Bored Ape which got stolen, and then he couldn't make his TV show, right? Even though he technically still owned it, but he had to get, the acquisition of it back by the person who stole it to buy it back so he can make his TV show. So the legal rights of what people have when it comes to NFTs and what the uses of it are very interesting, especially in the gaming space. With recently with Limit Break, who raised 200 million, who essentially just gave out NFTs for free, right? Kind of this free market, giving out everyone NFTs, but then the speculation starts to increase what you can do with it, and then also the price of it now, when nothing's actually been built for it right now. So that's kind of my general kind of interest and point of view what's going on in the space regarding that, because if more free NFTs might be happening in the free market, does speculation just exceed and then we run down any kind of ramifications of who owns what in that aspect?
Maybe if I can add up also a little bit to this conversation, I believe it's a very interesting moment also from an IP law perspective. We have so in France the system is very developed. I believe at some point you also had a law, and I believe you still have this law. It's actually this resale right, this royalty rights had to be collected by the reseller of the piece of art, and it was limited to certain piece work of art, like sculptures, stuff like that. And you kind of had this law at first. I believe it kind of highlights also the problematics that we have in the case of an NFT and someone trying to put a license into the NFT. You have the creator, you have the one who created this work of art, what we consider from a legal point of view as being a work of art. So imagine the picture of the Joconde. This is a work of art. We have Berne Convention defining it, etc. We have the licensor. So probably the company selling you the board API company trying to sell you the license over the work of art, if it exists. Because at first, we had there were a very interesting post on LinkedIn some times ago stating and asking OpenSea to actually add some kind of a license section on its website. I think it was brilliant. And this is really the case. So you have the licensor, the guy is giving you the license, you have the licensee, and the fourth person, you have potentially the token holder, because the token holder is not necessarily the same per guy as the licensee. So this kind of it's kind of problematic from a legal point of view, because you kind of needs to kind of make it work. Hopefully, license law are mainly made on a contractual basis, so you can write down a contract. Let's just step back one step, just to say that, for example, I believe that for board API at first you had no license. It was kind of invented 2 years after it was released. So, even that from a legal point of view, it's not really, because it's a contract. You cannot, it has to exist from day one. So you cannot really do that unilaterally. And the key point here is to say that, again, the goal when you create an NFT, when you want to attach license, etc., is to stay out of this securitization. So this financial law point of view, because usually when you have this kind of, let's skip a word, let's call a royalty a dividend, then you're and imagine that the dividend is vested on the fact that you invested in the work of art, and that it's some kind of a profit generated type of activity. In those type of case, you would be very near the financial market. And when you look at it from a legal point of view, why hasn't it been regulated as such, from the beginning? It's mostly for a historical purpose.
If I can react on that, I think it's quite different, because when you've got securities, when the buyer gets something with, he got a reward, he got returns, but it's the buyer that gets that, the dividend, etc. In the case of droit de suite, it's the seller that gets it. So he's issuing his own security for himself. I think it's not a security in that way. He's not selling a security. He's creating, in a way, a kind of security for himself. So it's not regulated the same way, I think.
It may depend on how you structure it, depending on exactly how you structure it. But my point here is to say that if you embed a right into this title that we call a token, and you said that everyone holding the token has some kind of a dividend right or do something like that, you're getting closer this financial law aspect. And this is kind of the problem that you want to avoid. And for historical purpose, at least in Switzerland, I believe that in France and Switzerland, it's very different. Those are very national regulated kind of topics. We don't have any regulation with regard to royalties and resale rights. So it's basically conventional law. So it's all about why we decided to regulate the financial market and not the art market from the beginning. Art market is not regulated, but when you look close at it, it looks like financial law. So yeah, with regard to my key point with regard to license and to NFT is just we should really make sure that the NFT that we create has some kind of also a legal value. See where is the value of owning some IP into the work of art, because otherwise it's just a piece fake token that actually exists on your wallet, providing not much interest. And it's also trying to to make sure that we stay out of this super financial type of area, which is a hurdle and a burden, when you step one foot into it. Yeah.
Been very insightful. Thank you all three of you for answering that question. Very interesting. If anyone's watching, any viewers want to ask any questions, we've got a couple of more minutes. We can answer one or two questions. But for my last question to all three of you, generally right now in the Web3 gaming space or Web3, is there any particular direction or kind of any company out there or any laws maybe been put into place that you are looking forward to that are kind of going in the right direction for everyone in general? So we start with Matthieu.
A law in the right direction. Well, I don't know, but I think one of the projects of many states now is to create CBDCs. So if we've got NFTs and video games on CBDCs, I think the question is quite different because everything will be, well, regulated by design. So if we got that, it's going to be really different. We won't be able to talk of Web3 anymore in this kind of system, not decentralized. It's re-centralized, but more, well, it's smart contract on the centralized system, and you can embed a lot of things in that, but it will be really different. So I think currently in Europe, and I think also in China, the focus is on that. The main regulation will be related to that. We also see some European passport regulation that are under process in the EU institutions, and it's mainly, well, they are proposing to use blockchain in order to create that with several nodes in different states in order to have a kind of passports that will be maybe, well, not decentralized identity, but, well, kind of centralized, decentralized by state identity with a very well certified contents. So maybe it can give a lot of answer in terms of AML, but currently we don't know. We are in a gray zone now, and we don't know what will be the use case in the next months. So I think regulation has to evolve, and practitioners are to adapt previous law to, well, the systems, the use case that are the more interesting for people. For example, IP, we have a lot of previous regulation on that, and we don't really need to adapt it. We already have all the system to deal with that, and with contract it's the same thing. For maybe financial law is quite different because it's new kind of financial asset, financial apprehension. But as we can see, we deal with that. In France, it's, well, more difficult because it's not done by a test. It's done by old system like GDPR. But GDPR and financial law have to evolve in Europe and France, that's for sure, for example.
I am aware that the UK government wants all passports and identification to be digital soon. So maybe they might be utilizing the blockchain for that, hopefully. Especially if they want it to be done in the next 5 years, I believe. David, anything from you?
Yes, I have a few comments on this. So I think there's some interesting things going on. I'm gonna try to connect college athletes in the US with Kim Kardashian and with Starbucks. So college athletes in the US now can make money on their name, image, and likeness, and they're issuing NFTs and making money that way. They're also achieving incredible wealth just by having big followers on the internet, which is where Kim Kardashian comes into this. Kim Kardashian announced a partnership with Jay Sammons to do Sky Partners, which is a venture capital firm that's going to leverage her 300 million followers. And then connecting that to Starbucks, Starbucks is issuing NFTs as part of their rewards program. I think NFTs as a part of a reward program are huge. And I think that's going to drive a lot of adoption in this space for people who are not into crypto, people who are just going to have digital assets that are NFTs on their phone, in their wallet, and they're not even going to know that that's what's happening, which is similar to what's happened here in the US with the NBA Top Shot, which is our top NFT platform. They don't even call it NFTs. They don't have any association with NFTs or crypto, but that's what's happening. And so I think you're starting to see this mainstreaming of crypto. It's just that it's not going to be called crypto or NFTs, but that's in fact what's happening. And I see those three sort of trend lines all kind of merging together. College athletes now are going to be real comfortable issuing NFTs and making money. And as they matriculate, into their 20s and 30s and 40s, it's just going to compound. And so I think this space is getting ready to take off, and I'm super excited to be here. So thank you.
Yeah, thank you very much for that. I mean, even with PlayStation, with digital collectibles, and then also with Square Enix with Final Fantasy merchandising. So they're all kind of using similar language when it comes to Web3, but in their own different way, again, to appeal to the Web2 users. And then ending with you, Gabriel, is there anything you're excited about?
Yes. So I believe overall the blockchain space is very exciting. I see many interesting projects, and again, it's all about the ecosystem. I really believe that Matthieu was speaking about this royalties right, and when you see that now it's being implemented in smart contract, I believe it's very exciting to be part of this evolution. And I feel extremely lucky actually to be alive now to see that happening, because we don't realize that this blockchain thing is just a revolution of hundreds of years of accounting system and way we run things. So I believe it's very exciting overall. Now, in terms of project, I'll see how the merge is going on before I have an opinion. But overall, I believe that with regard to NFT in the gaming space, I think it's incredible that we tend to have now models where you have economies that can kind of cross, the space of the game to go, further. And I believe that's what excites me the most as I was like a small gamer in my infance. It's really something that kind of puts the game to another level. And I found that really exciting.
Thank you for that. And I'd like to thank you for all of your time today. It's been very appreciated. We didn't get any questions, so I hope we covered every topic there. But you guys are also in the Blockchain Game Alliance, so if anyone else is in the community, can just reach out to you guys, and we can just have a chat that way. So thank you again, David, Matthieu, and then also Gabriel as well, and from me today as well. So thank you again for your time, and I hope you have a nice day. Appreciate it.
Thank you. Have a good day.